The sharecropping project, which we're going to do, requires you to look at a contract. Now, I can read you the words of the contract, and I will do that now. It comes from this book, and I hope to be able to make this available to you electronically. I understand the library can do that, but I don't know how long that's going to take. So I'm going to read it to you now. And this is a contract between Thomas J. Ross and all these slaves. Thomas J. Ross agrees to employ the freedmen to plant and raise a crop on his Rosstown plantation on the following rules and regulations and remunerations. The said Ross agrees to furnish the land to cultivate and a sufficient number of mules and horses and feed them to make and house said crop and all necessary farming utensils to carry on the same, and to give unto the said freedmen, whose names appear below, 1/2 of all the cotton, corn, and wheat that is raised on said place for the year 1866, after all necessary expenses are deducted out that accrues on said crop, outside of the freedmen's labor in harvesting, carrying to market, and selling the same, and that the said freedmen, whose names appear below, covenant and agree to and with said Thomas J. Ross that for and in consideration of 1/2 of the crop before mentioned, that they will plant, cultivate, and raise under the management control, that would be Thomas J. Ross's control, that they will plant and cultivate under his control of said Ross, in good faith, a cotton, corn, and oat crop under his management for the year 1866. And we, the said freedmen, agree, so they signed it below, to furnish ourselves and families, so it was children working too, the whole family would work, just as they had when they were slaves, that we would furnish ourselves and families in provisions, clothes, medicine, and medical bills, so they're going to take care of all those expenses themselves, which were previously provided by the masters. Of course, they were oftentimes inadequate, but and all every kind of other expense that we may incur on said plantation for the year 1866, free of charge to said Ross. Should the said Ross furnish us any of the above supplies or any other kind of expenses during the said year, we are to settle and pay him out of the net proceeds of our part of the crop. So he could, if he wished, pay some of it, but then he could take the money out of their share of the crop and retail price of the county at the time of sale, or any price we may agree upon. The said Ross shall keep a regular book account against each and every one of the head of every family, to be adjusted and settled at the end of the year. So oftentimes their expenses would eat up most of what they're made. They weren't able to get ahead under this system. We furthermore bind ourselves to and with said Ross that we will do good work and labor 10 hours a day, 60-hour work week, right? On an average. That's an average. So sometimes they'll be working late into the night even. Winter and summer. Winter and summer. The time to run from the time we commence to the time we quit. We further agree that we will lose all lost time or pay at the rate of $1 per day. Well, was that what it was worth? Rainy days accepted. And with sickness and women lying in childbed bed are to lose the time and account for it to the other hands out of his or her part of the crop. And so, if you were sick and you didn't work because you were maybe having a child, giving birth, you basically weren't going to get paid for that day. The others would be paid for that at the same rates that she or they may receive per annum. We furthermore bind ourselves that we will obey the orders of said Ross in all things, and carrying out and managing said crop for said years, and be docked for disobedience. All is responsible for all farming utensils and that is on hand or may be placed in care of said freeman for the year. So if they damaged a utensil, a mule, they would be responsible for recompensating them from that, which would come from the crop, right? Whatever they're making on the crop, that would be deducted. 1866 to said Ross. We are responsible to said Ross if we carelessly, maliciously maltreat any of his stock for said years, stock, the mules, to said Ross for damages to be assessed out of our wages for said years. And so it's signed below. And in the book it gives their names. And beside their names there's an X, which is the X that they marked when, is there for the X that they marked when they signed, because they couldn't write. They couldn't read, they couldn't write, and they signed X. They were pointed to where their name was. Some of them might have been able to read their name, but not much more than that, their name. And so they would sign by their name. Couldn't maybe write their name, but they could make an X. Samuel Johnson, X. Thomas Richard, X. Tenny Filch, X. Jesse Simmons, X. Sophie Pruden, X. Henry Pruden, X. So there you see a man and a wife, and this is maybe their children. Francis Pruden, X. Elijah Smith, X. So how does a contract limit the freedom of the laborers? Well, they're bound to the land. As we'll see, that can mean a lot. So other than that, if you just read the words of a contract, it kind of sounds like, well, yeah, it's a system under which the plantation owners needed these slaves to work to be able to bring a crop to market so that they could make money and pay their debts. They had debts and they owed banks money oftentimes for having bought those slaves, and they had to pay those back. And now they didn't have the slaves, they couldn't sell the slaves, but they lost the security for their debts, and so they needed to have these slaves working. And the slaves, however, were free, and at first they rejoiced in that. And so basically, part of the problem for slaves in the South was that they didn't have any land. There was some thoughts that they would be given land that would be taken from the leaders of the Civil War, people like Robert E. Lee, who had committed treason by taking up arms against the United States, violating his oath when he became a U.S. military officer. He took an oath not to do that, and it was a clear case of treason. There was some attempt to try him. He was never actually arrested. On the other hand, Jefferson Davis was arrested and put in prison for 2 years, and eventually, though, he was released, and they decided not to try him. And so nobody was really prosecuted under that, except for the one Confederate officer who ran the Andersonville prison, where the Union soldiers were kept, and they were very maltreated, and just it was an abuse of prisoners, which was against international law. And so he was the only one that was prosecuted, and I think he was hung. Don't really remember exactly. Anyway, this was a different scenario from what had taken place in other places where slaves had gained their freedom. In Haiti, where the slaves had risen up in a revolt and taken over, the slaves acquired the lands of the plantation owners, and therefore they tilled the land. They took possession of them as owners. There was talk during the Civil War. Certain generals would not only free the slaves, but would give them actually the right to till and work on the soil and collect whatever they made from that would be what they had. And so there was some hopes for some of those people on the South Sea, on the islands off the coast of South Carolina, that they would be able to retain that. There was also talk of legislation being passed by Congress to basically give every slave 40 acres and a mule out of lands that would be confiscated from Confederate leaders who owned plantations and had committed treason, and therefore were subject to laws of confiscation, which never happened. And you know, so although was an attempt to provide the slaves with land, that just never did develop. Instead, they immediately after the war found themselves negotiating for their labor with their former masters. And at first, because there weren't very many laws on how that was be treated, it looked like that could work. But as the leadership regained control over the state governments, they passed black codes that really kind of defeated that. Codes that basically said that the slaves had to, basically there were very vague laws. Vagrancy laws were one of the vague laws. Vague in the sense that it's not really provided that they would enforce it. So we see that even today. Laws are sometimes unequally enforced. So today we actually have in drug enforcement, we've had for quite some time, the war on drugs. Generally speaking, 90% of the people arrested on the war on drugs are for minor offenses and happen to be largely of the black population. Maybe only 10% of the population is white. White persons are prosecuted for minor offenses or drug offenses. And I think in those cases, maybe those are white persons who have, maybe committed bigger crimes. So there's no, there's been an intensive effort to catch in certain cities blacks who were smoking cigarettes. They would be stopping and searching them. And so this has led to the charge that even today we have Jim Crow laws, maybe not even just in the South, but in the North too. So slaves in Haiti required the lands, and they were able to actually make something of their society. Slaves here in our South were not actually able to do that. Instead, they would wind up signing contracts. And they were at first hopeful and happy. It was certainly a better situation, they thought, than what they had been in. But they began to see that it was maybe not so great as they thought it was, as it worked out. Anyway, there were reason to hope. So under the Johnson Reconstruction, so Vice President Johnson, who succeeded Lincoln, he was the one who was implementing the Reconstruction. Under his version of the Reconstruction, basically he wound up, although he had some indication that he wasn't going to do that, basically, pardoning all those leadership in the South, and they retook their positions leading society and created these black codes that allowed them to enforce that, including these vagrancy laws. So the vagrancy laws worked this way. If you didn't have a job, you could be arrested and hauled into court. And I mean, it was a minor offense of vagrancy, and so it was a misdemeanor, but you had to pay a fine. Well, blacks, because they had no way of really making money, except under these contracts, which very little money was actually made that way, so they were oftentimes very hard-pressed. You got to remember also that cotton was no longer the same crop as it had been. That is, the market for cotton had diminished for southern cotton because other countries such as Egypt and India had begun to produce more cotton because English merchants who were largely buying the cotton for their mills were using cotton from Egypt and India largely, which were English colonies. And they switched to more of a dependence on those while the South was embargoed. And so that they continued to get their cotton there, and they bought some cotton from the South again, but it was at much lower prices because there was more available, so supply had increased. And so those contracts that the slaves were saying to get were agreeing in which they got part of what was harvested was really not very satisfactory either to them or to the owners. So the owners were not willing to give them more because they would barely actually meet their own expenses. Like I said, they were oftentimes having to pay debts to bankers for what had been the purchase of slaves. And they no longer had security on those things, so if they had to borrow money, they didn't have the collateral that they used to have in terms of the slaves, which were used as collateral. And so, and because of the fact by 1866 it became clear that the freedom that had been guaranteed by the 13th Amendment was just not necessarily enough in itself. And so the Northern Congress passed, and it was later ratified, what we call the Reconstruction Amendments. So the 14th Amendment, the 15th Amendment, some people list the 13th Amendment along with that, which basically made for birthright citizenship, and they were freed by that. And you know, the emancipation had actually occurred before the 13th Amendment under orders, under military power. So Lincoln freed a lot of slaves, and he took his cue really from the generals, like General Butler, who had declared slaves free, emancipated, as contraband, because these slaves were being used to help the Southern War effort, so he took them as contraband. Well, that was kind of a twisted kind of thing, but they did that, and so a lot of slaves had been freed during the Civil War. As a matter of fact, when he issued the Emancipation Proclamation, it was that he declared these slaves to be contraband, and he did. And so he needed to have passed the 13th Amendment, which he did, and he fought to actually do that, redeeming himself from some of the things he said before being elected, which were probably necessary to get elected, because even in the North there was a lot of racial animosity towards blacks, and thinking that they were not that. So there was a fear that they would become too powerful. Anyway, so the 14th Amendment is a very important amendment, and basically it gave the slaves power. So no state shall abridge privileges or immunities of citizens, and you know that nor shall a state deprive any person of life, liberty, or property. Now that sounds like a pretty broad civil rights thing, and it says further that the Congress shall have the power to enforce these by appropriate legislation. So Congress could pass acts under that, and had the power to do so under the Constitution, because it's an amendment to the Constitution. And so they did. In 1875, they passed the Civil Rights Act, which was nonetheless declared unconstitutional by the Supreme Court, which basically had done much damage. And so the civil rights were pretty much on that. Privileges and immunities, the same thing. So the 14th Amendment talks about privileges and immunities being given to citizens of the United States and being enforced by the federal government. This was supposed to be exclusive jurisdiction with the federal government. But these were actually pretty well taken from the Southerners. And as to the federal court's ruling on these cases, it was at first, while there was some federal occupation, the Congress of the United States had passed military acts that were called the Reconstruction Acts. So these military acts divided the South into, I think, 5 districts under which the military had a power to enforce these laws. And so that was what it was. And so while they had that, they were actually enforced. But like I said, the Civil Rights Act of 1875 was denied, and other civil rights acts were ineffectual. Slaughterhouse cases indicated that the privileges and immunity clauses were very limited, and basically stripped those out of the amendment. And so today, when we passed in the 1960s, when we passed the Civil Rights Act, we did so pursuant to the commerce power, which was not really what that was supposed to do, but that's what they did, because it had been, the precedent had been set that these acts were not to be enforced under that. And so they made a lot of deal about it required state actions. So state action. So I've included these amendments in there, and I included the Civil Rights Act. You can read it, and I also included some of the cases that ruled on that. Jim Crow sovereignty. So basically what you had was states passing these laws that would abridge the freedom of these blacks in very clever ways, if you might say, or ways that allowed them to circumvent the law by, you know, saying, well, this is state action. So basically, they have the power to have local laws. Police powers were deemed by the Supreme Court to be something that the states retained, and that was something that states would have exclusive power over, despite the fact of these amendments to the Constitution. That's the way the court at that time read the Constitution. Now, these decisions were oftentimes 5-4. There was, at first, at least some support amongst the Supreme Court justices, but they were largely overruled by others, and so that's what happened. So we had Jim Crow sovereignty. Emancipation gave slaves a right to negotiate the terms of the contract, but actually it was not just merely a right, it was actually an absolute necessity, because they couldn't move around. They couldn't leave their land. They couldn't leave their residence except being subject to vagrancy. So if they walked into town, or they walked to the railroad station, or tried to ride a train north, they could be arrested for vagrancy if they couldn't show that they had employment. And these were laws that were largely enforced, again, against the blacks and not against whites, except in some rare cases. No longer able to control the former slaves to work hard hours, they created the Southern leadership created their own version of Reconstruction, preserving their caste system. Initially, they resisted federal Reconstruction by violence. The Ku Klux Klan and other white supremacist groups would use violence to do it. So Colfax massacres and New Orleans riots were examples of that. And this continued on for about 100 years. During after the World War I, you find it happening in Kansas City, where there are riots in which a lot of blacks are killed. And it was all because the local population felt that the blacks were getting too uppity. So Ku Klux Klan immediately, the ex-slaves, federal officials and charities did try to help them out, but there was not much they could do. And those charities and those federal officials would be threatened and sometimes murdered, hanged, you know. And white newspapers in the South fabricated fake news, which was spread in northern newspapers. They just took it, and there wasn't really much investigation or thought about these things. And this was to preserve the lie that blacks were not fit for self-governance, that they shouldn't have been given the vote. And so the black codes and the election laws that the states have the power to create under the Constitution basically discriminated against blacks. A lot of it was literacy tests, for example, was one thing, requiring them to be able to read. Since most blacks didn't read, that was not a problem. And this was largely only enforced against blacks. A white person showed up, they didn't require him to take a test. As a matter of fact, some of them had statutes that said if your grandfather could vote for 1865, then you weren't subject to these tests. And there were other tests and means by which they would do that. One thing was to move the place of the election, so the polling place would be changed in the last few days, just prior to the election. It was just without much notice, and they would send notice to whites but not to blacks. And so this was just another way of preventing blacks from voting. At first, after the Civil War, there was a good deal of blacks who voted, but after a while they gave up because of the violence. And if you showed up, you might well be threatened, and it was known you might be threatened for showing up at the polling place. And so the white newspaper fabricated stories about scallywags, which would have been Southerners, black and white Southerners, who tried to do something for the blacks, and and also the carpetbaggers, who were Northerners, who were seen as being people who were down there to profit from the governments in the South, even though a lot of these were pursuing charitable operations. And so you had you had state rights, and they would assert that they had the state rights under that, and that's what basically state rights is seen as overruling the amendments. And so you had a shift from national government, from national sovereignty, to this kind of dual sovereignty, which was not really part of our government immediately after the Constitution was founded. After our Constitution was founded, under the leadership of Justice Marshall, largely because he had starved at Valley Forge along with Washington and other of Washington's men like Hamilton, who was also a soldier there, because they had all starved and seen fellow soldiers starve to death because the states didn't provide enough provisions. So they couldn't collect money. The federal government of that time couldn't collect money, and it had no way of raising money. So they were dependent upon writing letters to southern states and asking them for money to carry on the war. And that just wasn't happening with enough frequency. And so that created, I think, a memory amongst Washington and his soldiers, and like I said, Marshall was one of those soldiers, that they needed a strong central government. On the other hand, the southern plantation owners from the very beginning realized that they wanted to have states' rights and control because they were worried that the northern states would eventually do away with slavery. And I think their worry was probably paranoid in some ways. Apparently, I don't think the North would have really have done it. And you'll see what happens afterwards. They didn't actually keep up the Reconstruction for more than maybe a generation. I mean, and the Reconstruction that was there was oftentimes ineffectual because these military, they didn't have enough soldiers to kind of govern and prevent the violence that was going on throughout the South. Oftentimes the soldiers were arriving late. They arrived late at the Colfax Massacre. They weren't really able to do much about the New Orleans riots and other instances. So there are numerous instances that can be looked into that, massacres, really. States' rights and the Black Codes. Basically, the leadership of the South was returned to the plantation owners, if you would. They were the people with the money. They were the people who traditionally had the powers, and they were reinstalled. If they weren't installed, they would have their buddies installed. And so as long as there's an occupying army, it was a little bit better. But as soon as that ended, and after the election in 1877, under the deal, as soon as that ended, pretty much Reconstruction became a joke. So the army was withdrawn after 1877, and de facto slavery existed then for another 100 years. So I'm talking about even while there was some Reconstruction, federal Reconstruction, even while the military, and Ulysses S. Grant as president was enforcing or trying to enforce the law, they were not able to do much because of the refusal of the southern leadership to obey the laws, and the refusing of people, their minions, the people who looked to them for leadership. And so states' rights and the Black Codes. The army was withdrawn, factory slavery, okay, and so these vague laws became more and more oppressive, and eventually you had where you couldn't even get on a bus without going to the back and sitting in the back, and and you couldn't actually travel if you were a black Southerner, despite the Civil Rights Acts that had been passed, despite the amendments that had been passed, saying that you would be given these civil rights. They were just not actually enforced, or they were declared to be unconstitutional. And even the voting laws were and there was a case, Giles versus Alabama, which was brought to the Supreme Court, and it was a clear case where the Alabama Supreme Court had refused to register these black citizens to vote. And so they documented it, and they brought it to the Supreme Court. And the Supreme Court said, well, we can't do anything about it. You have to look to Alabama to do that. Now, that's despite the language that there would be exclusive power in the courts to enforce that voting rights amendment, and the acts were there too. And so the acts were actually thrown out by the Supreme Court, and the Supreme Court had that. Now, interestingly enough, the man who wrote that Giles decision was a man who had fought in the Civil War and had been fought on the side of the North and had been almost killed twice, had been seriously wounded, shot in the chest one time. His lungs were filling up with blood, and shot through the neck. And despite that, he lived, and lived to be 90 years old or something. And so he actually was on the Supreme Court. And despite that, he was the one who wrote the opinion. Now, this may seem rather odd that he would be the one that wrote the opinion, but I think it kind of indicates how desperate the situation was. Probably he was writing a lot of the opinions because he was a very good writer. Justice Holmes was a very well-known writer, and even to this day, you can find lots of his quotations. And so he probably decided to write the opinion in order for it to be written by, in a way that was most favorable under the circumstances. It's the only thing I could say in justification of why he did that. But he basically wrote the opinion, said, we can't do anything about it, basically throwing up his hands. We can't do anything about it. It's up to that. We had Reconstruction. We did all these things. All that failed. We can't do anything about it. Supreme Court saying they couldn't do anything about it. And, in fact, it wasn't entirely wrong. They needed an act of Congress. They needed the Congress to appropriate monies to send soldiers down and enforce this. And so you see that, you don't see that again until 1954 when Eisenhower sent the troops to segregate the schools. And when the federal government, basically forced segregation on hotels and buses, and so we didn't see that for about 100 years. So that 1954 decision, that's almost 100 years since the Civil War. States' rights, so that's when it begins with Brown versus Board of Education, the modern era of Supreme Court adjudications. So I have in here the Supreme Court decisions, the Civil Rights decision, and also I included in here a Federal Hate Crime Act, which is a relatively new thing. But a reason I included that was to indicate to you that there are people who today say the Supreme Court is acting very similar to the way the Supreme Court used to act. So 5-4 majorities are finding that, for instance, the Federal Hate Crime Act is pretty much ineffective for the purposes that it was passed because of the Supreme Court. And also that's true of the Voting Rights Act that was passed in the 60s. So besides the Civil Rights Act of 1964, there was a 1966, 1967 Voting Rights Act, or was it 1965? There was a Voting Rights Act that basically was meant to guarantee the votes of that and would impose upon southern jurisdictions that had a history of moving goalposts. That is, they would change the location of the polling place and do other things to prevent blacks from voting, which had resulted in the 20th century, early part of the 20th century, up until this Voting Act was passed. Blacks were largely not voting in the South because basically they were worried that they'd be attacked. They were also, if they did show up, they would also oftentimes be challenged, or they would find that the voting place had moved, or they'd be asked to take a literacy test. Because of these things, they said, well, what the heck? Why should we go down there? Why should we bother? We're just going to subject us to abuse, and we might, if we go down there, somebody might show up at the door and haul us off and hang us from the nearest tree, Ku Klux Klan, for being uppity. Anyway, rationale offered by the majority in Morrison. The majority held that Congress lacked the power to enact these laws under the 14th Amendment, relying on state action doctrine. So that's the, still the basis being used today, the state action doctrine, basically that the state has these powers under the police powers. So that was going into disfavor. You didn't find those kinds of cases, and those precedents were still on the books. They weren't explicitly overruled. Just take a look at the Brown versus Board of Education. It doesn't explicitly overrule some of the previous precedent. It didn't overrule the Civil Rights Act. The Slaughterhouse case didn't overrule those acts, didn't overrule those decisions. And so they technically are still presidents. And, you know, there's this very good excuse then for conservative to say, well, I'm enforcing just the precedents that we have. And these things have not been changed. And so, although, you know, obviously it could be changed if you had a different court who was willing to do that. And what you had during the latter part of the 20th century was a court that wouldn't explicitly overrule certain precedents, but would just largely ignore them. And so that's a problem. So there's also the Prince versus United States. The United States was an important Supreme Court ruling in support of states' rights, and so that also says, so this is the new federalism. And so Shelby County versus Holder, this was the Alabama case in which they had changed the voting at the last minute, and the Supreme Court said that's okay for them to do that, even though they were supposed to be following the pre-clearance rules. They were basically, the Supreme Court said, well, we no longer have a problem. After the Shelby County case, many other southern states adopted laws and provisions and practices that were meant to restrict black voting. We'll see how that works out. So that's that. Constitutional nationalism, so I already said, now that's basically the fact that in the early days of our republic, under Washington and Adams and under Justice Marshall, we had a national sovereignty, and that has been eliminated by Justice Taney, who had been put on, of course, by the rather infamous President Jackson, one who had sent the Indians on the march of tears to Oklahoma and dispossessed them of the lands that they owned, and these certainly the Cherokee Nation amongst them had actually adopted many white ways and had been well adapted to European culture, if you would, but that didn't make any difference. They were all packed up with everybody else, and their lands were taken. Obviously constitutional. In that case, the court did say that that was constitutional, but the president and Congress ignored it. So it's our government is got different powers for different things. The Supreme Court has no powers to enforce. It has marshals. However, if a president doesn't, back them up, then, and you saw that with Eisenhower backing up the Supreme Court decision in Brown versus Board of Education. There was some thinking that maybe he might not do that, but he did do it, and he sent in federal troops to back them up. So the Supreme Court was going to send in the marshals, but this is a small force going into a largely hostile area of people who didn't want their schools integrated. And so you have constitutional nationalism, and then you have the contrary states' rights nationalism. So you have this dual sovereignty under states' rights, where the states are thought to be actually a sovereign and have police powers and basically have exclusive power of police, despite amendments that had been passed that certain crimes regarding race relations and certain actions by citizens can be required to recognize these civil rights that were meant to be given to the slaves so that they wouldn't carry the badges of slavery. And the power to govern has cycled, therefore. So I've got a slide that shows how it has cycled in the early days up till 1835 maybe. Justice Marshall ruled over a court in which he persuaded that court. It was largely him. He persuaded the court that they needed the national sovereignty. That was largely overruled when Justice Taney took over, and he largely pushed the states' rights agenda. He was born in a slave-owning family and continued to be a slave-owning family. And as far as he was concerned, the blacks had no rights that a white man had to respect. That's in the opinion of Justice Marshall in Plessy versus Ferguson. And of course that stood until it was overruled by Brown versus Board of Education, one of the few ones that was maybe overruled. Power to govern him. but that was an outrageous kind of crime. Some people say it was the cause of the Civil War. Certainly, it was quoted by Lincoln to indicate the extreme views of the Southern leadership, which they were so extreme that I think that largely defeated him. There were no doubt a lot of people who were maybe racist, who didn't believe in the owning of slaves under the conditions that they knew were happening. I guess Lincoln said to the woman who wrote the book, Uncle Tom's Cabin, "Oh, you're the little woman who started the Civil War," meaning that that book exposed the lies that had been fabricated by newspapers about how the slave system was working, how unfair it was. And so it's the power of literature, isn't it? It's the power of the culture. So that's it. So there's a lot I want to say, and basically I'm going to tell you that this is a project that the name of this video lecture will be the sharecropping contract. So I want you to take a look at the sharecropping contract. You have seen in other provisions on contracts that sometimes contracts are not enforced because they're unfair. And you can cite those provisions as providing a reason that these contracts could be thrown out, but only when you understand the circumstances under which those are enacted. So that's why I talked about the circumstances, how these slaves basically were forced to sign contracts to get employment. They needed to get employment, and the only thing they knew how to do was they weren't trained by their masters to do anything other than pick cotton, and maybe some of them knew how to run the cotton mill, cotton gin, you know, and so they knew how to do manual labor, but they weren't trained for anything else and had no experience to gain any other skills, had no education. The schooling was forbidden. If they weren't allowed to be taught to read, slaves that did read somehow taught themselves, and so you can read the book by you know, some of the Southerners who learned to write and read and became rather famous. And so this was largely a cause of Lincoln changing his views towards race when he had conversations with some of these more educated slaves who had taught themselves, and he realized that they were like him. He had taught himself. Lincoln had taught himself, so he identified, I think, after he became president, with these representatives from the blacks who were, you know, people who had taught themselves, and so he had said after the war that he was for giving the vote to slaves that were intelligent, and meaning educated, I suppose, but also to slaves who had fought for freedom by joining the forces, the military forces of the North, and he was for them gaining freedom. So this was contrary to Vice President Johnson, who was opposed to any slaves having any right to vote. Johnson was totally okay with the Dred Scott decision, I believe. He believed that the blacks were inferior and they had no rights that a white person needed to respect. I believe that would have been his position. I don't ask me to find something that shows that, but it just is generally his view of the situation was he was not going to do the reconstructions. So Eric Foner, who writes a lot about Reconstruction, is of the opinion that the only reason the Reconstruction in the South worked at first was that you had these veterans of the Civil War, Union men who had fought for the North, who were in support of these amendments and these legislation, and they wanted to see the blacks have something. That's not to say that they were necessarily free of any sort of racism, but they certainly were not for the extremity in which the blacks found themselves. They were not in favor. So to the extent it worked, it was probably because of that, he said. But then again, you see Holmes, who was the representative of those class of people, fought in the Civil War for the freedom of the slaves, and he definitely fought for the freedom of slaves, not for the Union. His mother was an abolitionist, he was an abolitionist, some of his friends were abolitionists. He was offered the chance to be an officer, get a promotion to lead black slaves in battle, but he refused that. This was after he'd been shot a couple of times. But he did fight throughout the entire war, but he was working in the latter parts as a courier not directly in the battle. However, you can be shot as a courier too. And so, yeah. And like I said, he was a great scholar and able to write very able opinions. And sometimes, I think, would vote a certain way so that he could get so that he could write the majority opinion. So I think that's pretty much what it is. I also give you here certain video bibliography. I got two, maybe I'm going to have three, at least two videos that you could look at that talks about this. One of them is by Eric Foner. The other one is by a lady named Michelle Alexander, who is a lawyer, JD, and she's also taught a school. She's got a PhD, but she's like me. She's got a JD, and she's able to teach legal subjects. She's no longer teaching, but is involved in a more civic work, not so much for the money. And so she's making a lot of money, but she's not in it for the money so much. And so those are that. And then I've got a bibliography of books that also goes in there. And so you'll get those kinds of things. And that's it for tonight. Thank you for coming, and I hope you work on the project. And I might send other instructions by way of an announcement, which would be just simply maybe something for you to read from me. But because I don't think I will have time to do another video lecture on this. But I've given you, as best I can, in one lecture, what I think will help you do this project. And you can look up and read things on your own if you want. Like I said, you can look at those book sections. I'm going to see if I can get those book sections to you electronically. The library tells me that we can do that they can, copy some of the pages out of these books. However, I wanted to put them on the reserve, and she said they're not doing that. They're not putting books largely on reserve. There may be some exceptions, I guess, for certain subjects, but she said they definitely could do it on an electronic basis. And so I'll send you maybe the sharecrop contract. I'll copy that out of the book maybe and have that sent to you electronically. You can see what it is. I'll send you some things that maybe Eric Foner. And you can go on the internet and find his videos on, same as this one, on, on the internet. So it's in the same location as my lecture. So, that's it. Thank you very much.